Good afternoon, everyone, and welcome to the third webinar in our series of webinars, Life After Furlough. Hopefully, many of you have joined us for the last two webinars, but today, Oliver Tasker and I are going to deal with the changes announced by the Chancellor to the Coronavirus Job Retention Scheme last Friday. So I'm sure you were all poring over the announcements as they came out on Friday evening. Hopefully, Oliver and I will be able to help you with some of the key issues and queries that have arisen since Friday. So we're going to cover what we consider to be the main points in question, and then it's going to be over to you to ask us any questions that you want to ask us live. So at this stage, if you perhaps listen to Ollie and I cover the main points, and then I'll let you know when you can ask any questions. For those of you that have been on our previous webinars, we prefer you to do that by clicking on the participants icon at the bottom of your screen if you're on a laptop, or the top if you're on an iPad, and then doing raise your hand. So we come to you and pan to you live to ask your question. If you fear asking your question live, by all means put it in the chat box. We will try and get to it, but there's no guarantee that we will actually manage to get to your question if it's just in the chat box. As at the spring bank holiday, the Chancellor announced that the Coronavirus Job Retention Scheme had helped 15 billion pounds to 1 million employers across the UK, claiming for 8.4 million employees. So clearly it's been a massive lifeline for businesses, and the extension to the scheme that was announced has been widely welcomed by lots of groups. What was the main announcement really was that there would be new flexibility with the scheme. So, Oliver, can you help the audience with what is that flexibility that's being offered by the Chancellor?
Yes, so from the 1st of July, we're seeing a new principle called flexible furlough that will be introduced, that the Chancellor has now announced, meaning that businesses can now bring employees back to work that were previously furloughed on a part-time basis. And it's actually 1 month earlier than they initially anticipated and announced, which is great. And it's good that businesses are going to have that flexibility as well to bring people back on a part-time basis. So what this means is that employees can carry out some work for the business whilst you can still claim the government grant under the retention scheme for any hours that they're not working. And we'll come on to that shortly. But remember that the flexible furlough is an option. If you're not in a position still to provide any work to those employees, then you don't need to make use of this option at all. And employees can continue to be placed on full furlough until the end of October if needed, albeit we'll get on to the contribution that businesses are going to have to make towards that and towards the scheme now as well, which was also announced. So in terms of payment, what are businesses actually going to have to pay to an employee for hours that they're working? And that really is going to be their normal wage that they'd expect to be paid as normal under their contract of employment, meaning that the business will also be responsible for national insurance contributions, pension costs, as well as normal. One area that's unclear, and you may hear us say that quite a few times at the moment, and a few questions, is, well, is there any flexibility for the business to actually agree to any pay cuts as well with those employees before you bring them back to work on a part-time basis? So at the moment, you may have agreed pay reductions to the staff that are continuing to work within the business at this time to help in terms of finances, cash flows, etc. But now you're going to bring people back on a part-time flexible basis. Could you look to agree to a reduction in pay for them compared to their normal pay? And then if that's allowed, how will it then impact upon the grants that you can get under the job retention scheme for hours that are not worked? Because if you recall, your current application under the retention scheme is based on the employee's pay in their last pay period prior to the 19th of March, or their average pay if it varies. So maybe an implication in terms of that, and we await further guidance on that point. So what can you actually claim for an employee on flexible furlough through the scheme? So the grant is going to cover any hours that the employee is not working. And that's going to be by reference to their normal and their usual hours in a certain claim period. So the grant and the cap will actually be reduced in proportion to the hours that they are not working. And what this means when you come in to submit your claim for flexible working, flexible furlough, is that you need to report the hours that the employee has worked, and also the usual hours that they would have been expected to work during that period as well, so that you're justifying and you provide an evidence of the amount you're claiming under the scheme for those hours that the employee is not working for the business. So what that really means in practice is that you're also going to need to set up a system to track hours. So those that are worked and those that are not worked by particular employees, and that may be a challenge, particularly for salaried employees that are on furlough and whose hours you may not necessarily track, because they're on salary pay. They get paid the same amount each month regardless of the hours that they work. So again, that's probably an area that we're going to have some further detail when we do get that more detailed guidance further down the line.
So for an employer to actually be eligible for the grant, what have they got to do with their employees?
Yeah, so when you're looking to bring an employee back on flexible furlough, so they're going to come back to work part-time, the first point is that you have to agree with the employee, with the individual, the new flexible furloughing arrangement, and have that agreement confirmed in writing. So similar to what you did when you placed employees on furlough initially, you have that agreement in writing. So what that will set out is what you are asking them to return to work to do in terms of hours, and then how that will impact upon their pay. So you'll set out what the business will pay, so they'll receive their normal pay for the hours that they work, and then you will be applying for the retention scheme for any hours that they do not work. So what that means as well is that it appears at this moment in time that you could look to change the working arrangement, so that flexibility week to week potentially. So hopefully it'll give you flexibility as a business to change that. And it's important you record that in writing, because the minimum claim period, the flexible furlough, is a week. You don't have to do it week by week to make that claim. So if at the moment you're putting in, say, claims every other week or claims monthly under the retention scheme, you can do so. The minimum period of time is a week, the flexibility side.
Oliver, you mentioned that there's going to be further guidance on the scheme. When are we going to hear more about that?
Yeah, the Chancellor said that the detailed guidance about exactly the flexibility, about the payment side as well, and the calculation of the payments is going to be released on the 12th of June. So we'll do some further updates after that time. Really, that's a brief overview of the flexibility that you'll be able to have under the flexible furlough principle that the Chancellor announced. And now's an opportune time. We're going to launch our first poll, which is going to be asking you, do you anticipate your business will be making use of this flexible furlough scheme? So if you can all cast your vote, hopefully the poll has come up on your screen. If it hasn't, there is a poll button at the bottom of the screen for you to click on, and it should then appear. Slowly creeping up in terms of numbers. Really, there's been great calls from businesses to have this flexibility from the very beginning for those that continue to operate, so I anticipate it is going to be widely used. We'll close the poll there, which shows that 58% of you, for those that have voted, are anticipating to make use of the scheme, which is good, and some that will decide nearer the time, particularly when we get the details behind it, which is understandable. But there really has been a cry for this flexibility as part of the scheme from the very beginning, and the Chancellor's introduced it. Now we're going to see the tapering out of that financial support from the government. Now, Theresa, the Chancellor also confirmed, in fact, that the scheme's going to be closed to new entrants. When's the last time that a business can actually furlough an employee?
Thanks, Oliver. Yes, this is quite a contentious area in the few days that have elapsed since the Chancellor made his announcement. So in his announcement, the Chancellor said that it will be closed to new entrants from the 30th of June, so from the end of this month. So from that point onwards, you will only be able to furlough people after the 30th of June if they have been furloughed for a full 3-week period. So we all know as employers that for someone to be furloughed, for the employer to be able to claim the money back from the scheme up till now, they have to be furloughed for a minimum 3-week period. So that needs to happen before the 30th of June. So that means that the last time you can furlough somebody for the first time is next Wednesday, everyone. That's the 10th of June. So if you haven't got somebody furloughed or prior to next Wednesday, where next Wednesday is your last day to actually get them onto the furlough scheme, so that you can then take advantage of what Oliver's spoken about in relation to the flexibility.
And will businesses still be able to furlough employees after the 1st of July if they're not currently furloughed at that point?
No, so the reality is they need to have been furloughed for 3 weeks at some point after the start of the scheme. So if somebody is furloughed at the moment, but say next week they come back because you need them to work and then you furlough them again, that's fine, because you previously used the scheme for the 3-week period. But you can't put anybody onto furlough for the first time from the 1st of July onwards. So your last opportunity really as employers, so to get them onto the scheme by next Wednesday.
And when's the first time that a business can submit a claim under the new scheme with this flexibility?
So that is from the beginning of the flexibility, from the 1st of July. So employers will be able to make the claims pretty much straight away. What is important though is that for the claiming moving forward, you'll no longer as an employer be able to overlap months. So if you previously submitted claims that have, because of your payroll dates, have gone between calendar months as employers, you're not going to be able to do that moving forward. So that's necessary to reflect what Oliver was talking about in relation to the hours, the normal hours of work that somebody would be working, what they're not therefore working. So we're in a position where you've got to restrict yourselves to monthly claims. Now, you can put in a claim under the new scheme on a weekly basis, but you just simply cannot overlap on months. And one important thing is that the number of employees that an employer can claim for, obviously that cannot exceed the maximum number that you've claimed for in the pre-period to the flexibility. So that is all obviously to try and stop any fraud from occurring, by making sure employers aren't trying to claim for more employees after the 1st of July than they did in totality before the 1st of July. So yeah, the scheme can be made available and claimable from the 1st of July. So Oliver, the Chancellor's confirmed that the businesses will need to obviously contribute, and you touched on that earlier. Can you take us through when that kicks in and how much that's going to be? We've got a slide for this, so Oliver's just going to launch the slide so that you can see what the difference is going to be in the different months.
Yeah, I've just launched the slides. Hopefully everybody can see that. Okay, quick nod if you can. Yeah, good. So we all know under the scheme, the terms of the scheme at the moment, that you can recover 80% up to that cap of £2,500 per month for anybody that is furloughed. Now, part of the announcement that the Chancellor made last week is the tapering off of the financial support from the government in terms of furlough, and it's also why that they've introduced this flexibility as well, that a business can bring back people on a part-time basis to really slowly integrate the workforce back to work so that the financial support will gradually drop off. And that's certainly the idea behind the taps being slowed with the financial support that's going to be there. Now, one point from the employee perspective is that throughout the period, so if they're on full furlough or flexible furlough, they're always going to be receiving the 80% up to the £2,500 per month. But what we do know now is that from the end of August, an employer is going to have to contribute in terms of wages as well, as that support slowly goes down. So on the screen now is the table to show the various different payments that are going to have to be made. So in terms of June and July, the financial support remains as it currently has been under the terms of the scheme. So up until the end of July, you can still recover as a business up to 80%, so the £2,500 per cap per month, plus employers' national insurance contributions and auto-enrolment pension costs. The only change come August is that the business is going to be or going to have to make the national insurance contributions, pick up the tab for that, as well as auto enrolment pension costs as well. So that's the only slight tweak in terms of August. For September, this is where the changes start to kick in. So the government support drops to 70%, up to a cap of £2,187.50, as you can see on the screen. And the employer is then going to have to pick up the 10% to top it up to 80, together with the employer's national insurance contributions and pension that has already kicked in. And then, as you can see, from October, that is then going to drop 60% from the government, and the business will then have to pick up the remaining 20%, which is up to a cap of £625. So you've got the figures on the screen there that shows how it is gradually going to taper down. I'll just stop sharing my screen there, and we will send out the PowerPoint as well, so that you do have all of the figures as well.
So in relation to the scheme, when it changes, can the employer still top up like they may be doing now, Oliver?
Yeah, businesses can still top up. So if you do want to top it up above the 80% cap, you are free to do so. So that flexibility still remains. Now, businesses may be taking a slightly different approach to that as the scheme has progressed. Some clients at the beginning were supportive and were topping up, and then as the situation did progress, that reduced down to the cap. So again, it may be that you as an employer may take a different decision on whether you are going to continue to top up under the scheme or not. So a question for you, Therese, and I'll also get to another slide up on the screen, is how does HMRC anticipate that claims are actually going to be impacted by this phasing down of the monetary support?
One thing that has happened in relation to the claims that have been put in so far is that, with the early assessment of those, it seems that about 40% of employers have not been making claims for the national insurance costs, or in fact the employer pension contributions. So whether they have been mistaken and not applying for everything that they needed to or could apply for. So about 40% of employers are not going to be affected by that change in August if their employment patterns carry on as they are now. there's also sort of indications from the stats up to the end of May claims that about 25% of the monthly claims are actually below the threshold of where the employer's national insurance contributions and auto-enrolment pension contributions are due, probably for flexible, part-time agency workers maybe who are being paid less. So again, no employer contributions are going to be expected for those employees either for August. So really, the large numbers that are going to be impacted start really being impacted more from September than they do from the August changes. As you said, I think we've got a slide coming up, Oliver.
Yeah, if I launch the slide now, if I can go on a stage. What's going to be the average cost then for a business under these new terms?
So July, absolutely staying as we are now. So no monthly cost to the employer, and that's the great saving. The August, as I mentioned, some won't be affected, but those that are currently making a claim for the national insurance costs and the pension contributions, you can see from the slide there that you will be paying on average £69, which is, as a percentage of gross employment costs, is 5% that you will be contributing. And we can see that then rises in September to, on average, to £207, which is 14% of gross employment costs. And in October, when we're told the scheme is definitely going to be ended, the contribution from the employer there is £345 on average, which is 23% of the gross employment costs. So having gone through that, we've then got another poll for you as will the extended scheme stop your businesses making redundancies? So obviously this is what the Chancellor is trying to avoid. He's trying to stop businesses making redundancies. He's trying to allow you to get your employees back to work gradually from the beginning of next month, for things to develop so that hopefully you do not need to make redundancies. So I can see the numbers are coming up. So we've got, will the extended scheme stop your businesses making redundancies? Yes, no, or under continual review. And I think it's unsurprising probably that we're in a situation where the most of you are saying, the vast majority, 56%, is that it's under continual review. I certainly think where we are now at the beginning of June, it's going to be very hard for employers to say, definitely, we're not going to be making redundancies. Some people will be part way through that anyway. But the purpose of this is that things have been changing week by week, month by month for all businesses from different sectors. So good that people will be keeping that under review. We're now at a point where people can, if they wish, raise their hand or put questions in the chat box. We've been through the sort of the key headlines around the changes that have been announced. So if anyone wants to ask a question, just as a reminder, if you go on the participants icon and then raise your hand, I can see we've got a hand up by Martin Lure. So over to you, Martin, to ask our first question, please.
It's actually two, if I'm allowed to.
Yes, of course.
The first one's an easy one, probably. Can you have some staff receiving 80% and some staff receiving the top up?
In theory, yes. Most employers, I have to say, in my experience, and I'll turn to Oliver in terms of the ones that he has been advising, most employers have made an across-the-board decision to either top up or not top up, because then it prevents any risk of any claims or unfairness within the workforce. I could see some employers could do it differently. If, for example, you're a particular short supply of a skill set, and therefore you wanted to make sure those people, stay with you and aren't, directed off to other employers that might be advertising. But yeah, generally, in my experience with the large number of employers I've been advising, people have done it across the board. Oliver, have your employer clients been likewise with that?
It's been the same, yeah, blanket across the board, consistent approach, just to avoid any risks of any claim of differential treatment on any grounds, but also any impact on morale or employee engagement as well. So if it became apparent to different workers, different areas of your workforce departments that they are not receiving a top up, it's then going to create difficulty for hopefully when everyone's back to business.
Okay. Second question is, we've currently done 100% of full salary top up through to the end of June as a business, which means we're essentially paying the additional 20%. This flexible furlough opportunity made me feel, as I was falling asleep last night, thought, right, I'm going to get we've got about 40% of our staff on furlough, maybe 35. And I thought, right, I'm going to get everybody in for one day, which is 20%. And I'm going to carry on paying 100% and I'll claim my 80. But it doesn't work like that, does it? It's only 80% of the time that they're off.
Absolutely, yes. As Oliver covered, it's the hours that they are not working that the 30% is covering, yes.
Okay. It's just with this going on for longer, there's some people that have been on furlough for the entire period and will be on furlough for the entire period that I don't expect to make redundant. And I felt like they should be moving to the 80%, whereas the people that are still doing some hours and some work should be topped up. That's why the question around having some on and some off came from.
Okay.
Okay. Thank you.
Thanks a lot, Martin. Wendy, I can see Wendy has her hand up. Over to you, Wendy. Wendy, I think you're still on mute. Wendy, if you're trying to talk to us, we'll try and unmute you if we can. If not, you need to press your screen and unmute yourself. Okay, whilst we're trying to do that, let's have a look at some questions in the chat box. Do you want to take the first one, Oliver?
Yeah, so the first one, Matthew, can we still rota staff on furlough? Answer to that being yes, you can still look to do that. And I anticipate when this flexibility kicks in as well, that many businesses will use that to have staff return part-time and maybe utilise a rota to do that as well. And gradually, hopefully as work starts to increase, the workforce can start to work part-time and you rota people in that way. And it may allow you as a business to then comply with health and safety requirements. So if you're going to get people back in the workplace as well, you may not be in a position to get everybody back at once. So you could utilise the flexible working, flexible furlough to do that and stagger it on a rota basis as well. So there's that flexibility, which is going to be important. And that's certainly what's anticipated from the Chancellor as well.
Now, Charlotte has asked the burning question on the chat, which I alluded to earlier, which was, if an employee was previously furloughed, but is currently now back in the workplace on full or maybe short-time working, can we put them back on flexible furlough at any time, or do they need to be on furlough at present in order to redeem? Now, this is the point I covered in my part, where I was saying that the government have brought in this new rule about the last time you can furlough somebody is the 10th of June. Certainly, our reading of the government guidance that came out on Friday is that provided somebody has previously been furloughed for the minimum 3-week period at any time during the running of the scheme, then you will be able to take advantage of the flexible furlough scheme that is in operation from the 1st of July. There are some solicitors and commentators out there that are saying that employees have to be on furlough between the 10th of June and the 30th of June for you then to take advantage of the flexible scheme from the 1st of July. Now, that is not how we read the detail that has come out, and Oliver and myself are in firm agreement with that. But as I say, there are some commentators out there saying that is a requirement, but we don't agree. Is there anything particularly you want to highlight around that, Oliver, the wording or anything around that?
No, I'll just re-emphasise that it'd be counterintuitive to have to furlough everybody from the 10th of June to the 30th of June to then be able to make use of this new flexible furlough. And if that was the case, then it would be highly unlikely that the Chancellor would then wait until the 12th of June in order to publish the detailed guidance on it. It would have had to have been made specifically clear from when he made the announcement last week. And purely on the reading of the guidance that we have so far, his announcement and information from HMRC, it appears, and we interpret as Teresa said, that you do not have to have everybody on furlough at that date, the end of June, who you may want to place on that flexible furlough scheme moving forward.
Andy, I can see Andy Alcott has got his hand up. Andy, do you want to ask your question?
Yeah, thank you. So along with everybody else, we've learnt lots of things about our business and already identified, we believe, a couple of areas where we will be making redundancies in specific departments. Does the announcement of the flexibility on the extension of the scheme mean that we should be hanging fire with any of those decisions, or on the basis that things can change over a 2 to 3 month period with workloads and jobs disappearing, or do you think we are still fairly robust in that decision?
Oliver, do you want to take that question?
Yep. It's all about your business needs at this moment in time. So given that the scheme's been extended up until the end of October, albeit with the tapered support from the government, does not stop you as a business from saying we need to act now, we need to make redundancies now, at all. So you are not risking your position within the business by making redundancies now, even though the retention scheme is still there. If you've got the genuine redundancy reason, you can proceed with the redundancy situation.
Perfect, thank you.
Liz Knox has asked on the chat, can we mix an employee so sometimes they work part-time and sometimes they're on full furlough subject to the qualifying periods? And the answer to that, Liz, is yes. That's why when I covered that we can only deal with things now in blocks of weeks, and we can't, the government are not going to allow a claim to go to HMRC straddling months. And part of that is so that it does give you that ultimate flexibility, so that, as Oliver covered, you can either rota people on and off, or you have a lot of orders come in and therefore you need that week to have all hands on the deck. But it might be the following week you haven't got the orders, and therefore you need to reduce those hours. But the key is, as Oliver said near the beginning, you've got to have this all in writing and agreed with the employee. So you can't be chopping and changing with them unless you've got an agreement in writing with them to cover that. Has anyone got any further questions at all, either that they want to raise in the chat box or put their hand up? Because I think we've got through them all, haven't we, Oliver, unless I'm missing some in the chat box?
No, that's all of them covered on the chat. Oh, one more from Yvonne actually. Is the weekly claim a working week or a tax week? It would fall within their normal working week, as far as I understand it, rather than a tax week.
Yes, I agree. Whatever their normal working hours are, you claim for that week. Yeah, definitely. Okay, Oliver, I think you've got, if there are no further questions, oh, hang on. Someone keeps putting their hand up, but we're not seeing them. It says I can't see anyone with a hand up. Can you, Oliver, on your screen? Oh, Graham Hunter.
Apologies for the late question. Just something that I could have really asked on a previous call, and thank you again for the very good presentation today. Really clear and concise. Temporary. If I have a couple of temporary employees who were furloughed when the scheme first came along. Now, back to your point about continually reviewing the requirements. It will probably become increasingly likely that we won't want these temporary employees to come back into the business. We won't have the work for them. Now, obviously, their temporary contracts were open-ended. Well, one of them had an open-ended contract. Okay. Now, obviously, we'll probably want to make a move on that when we start having to, when later in the year, we start in September, we start to pay 10% of the cost. Suddenly, if it's inevitable, we're not going to have that employee back, then we would probably terminate the contract. In the case of the other employee, there was a fixed end date, which was end of July, and that individual's on furlough. Do we have any options under the furlough scheme to extend that individual's furlough arrangements, or given that we had a contractual end of contract end of July, do we just have to stop the furlough claim at that point? So I guess my question is, where we've got somebody, where now we know that we're likely to have to terminate a temporary employee, should we stop claiming now? If morally, on the basis that we can still claim in full till the end of August for that employee, and he or she will benefit from that and not endure hardship. But we know now we're not going to have that individual back. And in the case of the other one who's on a fixed term contract or fixed term that ends at the end of July, can we strictly not continue any furlough claims after the end of July?
I'll pick that one up. So the fixed term contract, what the guidance states is you've got some flexibility. So you could make a decision actually to extend that fixed term contract for them to remain on furlough. Now, if realistically as a business, you know that you're not going to need that individual back and simply you don't have the work there for them, then realistically, you're probably better to end that relationship now and confirm that when their fixed term contract expires, did you say at the end of June or end of July, whenever that may be, that it will end at that point.
Yeah. Okay.
For the other individual, again, if you realistically don't have work for them to be coming back at all, then I would end, if they're doing a similar role, I would end it at the same time with them as well.
Okay, no, thanks, that's clear. I just didn't want to be abusing, fall into that category of abusing the scheme. Okay. Absolutely,
yes. There's a question on the chat from Matthew that assume the smallest period is now just a week. Presume you mean the claim period, which is a week, yes. But if you'd previously done it on a longer period of time, so if you'd always submitted your claims on a monthly basis, then you can continue to do that.
Got a question on there about when an employee works variable hours, how do we calculate the unworked hours? And I think the answer to that is we don't know the answer. We need to wait until the guidance comes out more guidance comes out on the 12th of June. So that's a week on Friday. So we'll cover that in our next webinar when we've got further guidance. So yeah, there's no guidance on that at this present time. Oliver, do you want to see if there's anything else in the chat? We've got a few more there.
Tim asks if furlough pay is furlough pay used to calculate redundancy, or is it based on assumed full pay? So it's going to be based on previous hours and pay rather than your 80% £2,500 cap. So you calculate your redundancy payment as normal.
Valerie's talking about those people that have childcare responsibilities, the positions that they hold have been made redundant, are we at risk of discrimination if we make them redundant because they just happen to be taking care of children? Well, yes, you can't select them solely on the basis that they are caring for children for redundancies. But if your question says that you've had to change your business model and therefore presumably you will be consulting with all of the employees, or you need to, all of the employees that hold that job title, you need to be consulting with them all about redundancy and not just selecting those individuals that happen to be taking care of children. But if indeed everybody that holds that job title in fact is also caring for children, then you need to select them for redundancy on a fair basis, and it wouldn't be unfair for you to do so if they're all in the same position with regard to that.
There's a question in the box that was covered by you, Teresa, asking, my staff have a pay period from the 24th to the 23rd of the month, and they're paid on the last day of the month. At the moment, I claim when the payroll is processed on the 24th. Can I continue to do this, please?
The guidance does at the moment specifically state that you won't be able to overlap months. But what it says is employers who previously submitted claims with periods that overlapped calendar months will no longer be able to do this going forward. Now, that might be a position where they are stating that some employers, irrespective of payroll periods, were putting claims in across the months. I think we're going to need to wait for some further guidance a week on Friday in relation to that, because it does seem quite complex if you've got your distinct pay period for you to then have to recalculate that outside the pay period, because that's going to be quite time consuming for you to do that if it's falling between payroll periods. So common sense would say, Sheen, that you ought to be able to claim for your payroll periods on the month. It's just, as I say, my only query would be that it specifically says that they cannot overlap months. So we'll await some further guidance on that.
Yeah, I anticipate that HMRC will want to segregate claims into the month, for then it's easy for them to process the claims with the tapering down of the financial support available. So it's going to be a complete pain for businesses to adjust the claims to reflect a calendar month, but that's how it appears at the moment. Wendy's asked, if we want to start the redundancy process for some employees during furlough and this leads to redundancy, can the notice period be paid and still claim the 80% back? Now, you can't seek to reclaim a payment in lieu of notice, but if an individual that is dismissed, made redundant, remains on furlough for their notice period, so you simply keep them on furlough for that period, then you can claim back the 80% in terms of that notice pay from the retention scheme.
Donna has asked something that actually follows on from that, really, because she's said to us, if you make someone redundant during furlough, should I give them an extended notice period to the end of July, given the government will pay 80%? What I'd say to you, Donna, is when you're paying them notice, you've got to top up to 100%. So don't give them an extended notice period. This might sound a bit technical, but give them the notice period that they're contractually entitled to. Let's say it's 2 weeks. So for those 2 weeks, you have to pay 100%. You have to top up the furlough to 100%. You are then able to say to the employee, albeit that your notice period has run out, I am kindly, as your employer, going to allow you to remain on our books till the end of July, and I will claim furlough for you for that period of time, and I will pay you the 80% that the employer is going to receive. So it's not extended notice as normal, and then an agreement that they'll remain on furlough to the end of July. One point about that, though, if they're on your payroll, they are accruing holiday pay. So you need to be thoughtful about that and say to them, what I've been advising employers to do is say to, when they give the notice, also say that during the notice period, the individual must take all of their holiday entitlement that is accrued up to the end of the furlough period at the end of July. If anyone needs help with any letters around this, obviously get in touch with Oliver and myself, because the letters giving notice of redundancy need to be very carefully worded so that you don't end up paying, you know, more than the 80%. Otherwise, you're in a position where you've, you know, done the right thing by allowing them to stay on furlough, but then you end up having to pay more out in holiday pay, for example.
I think so. Nick Page had a question. Has there been any indication of when HMRC will allow amendments to previously submitted claims? I know that HMRC did state previously that they were looking to add that capability to the online process. I've not seen any update on that though. Have you, Teresa?
No, I haven't, and I did check in the last few days because I had a query from an employer. So yes, no release yet of when you're being able to amend those previously submitted claims.
Although Lynn has just added in the chat that you can phone HMRC and they will amend it over the phone.
Oh well, so if it's not too difficult, then hopefully that is Lynn, they'll amend it over the phone. I've never known the HMRC be so helpful in all of my career as they've been since the launch of this scheme. When it was launched, and people were saying, oh, you'll be able to claim in a few months, I was poo-pooing and saying, no, it takes HMRC ages to do anything, and they really have pulled out all the stops on this and set the scheme up. And Lynn is saying if it's straightforward, but they might take a while to answer. Yes, as long as you can do something else while you're waiting for them to answer the phone.
We've got a question from Andy. Can you still ask staff on furlough to take holidays and top up to 100%? Yes, holidays can be taken during furlough, absolutely. And you as a business can ask employees and oblige them to take holiday during that furlough period on the condition that you give them double the amount of notice that you're asking them to take. So the normal principles apply in that regard. And yes, it needs to be paid at 100%. So the normal calculation for holiday pay, and you can then claim back the 80% stroke £2.5 cap per month under the retention scheme.
I've got a question in there that says, if we have not yet submitted a claim but have had individuals on furlough since April, so I'm presuming that made no claim for any employees, is the 10th of June a deadline for us if we want to be able to access the scheme going forward in August? So it's not the 10th of June, it's the deadline. That's the deadline for putting people onto furlough if they haven't been on furlough before. So that does not kick in for you, because from your question it looks like they've been on furlough since April. But you want to be able to access the scheme going forward. So the question really around that is, do you need to make a claim in June, by the end of June, so that they know that your person is on furlough? I would say it would be good practice and a good idea to make a claim by the 30th of June for what has been on the person that's been on furlough from April to the end of June. Make your claim so that you are sure you are then falling within the scheme rules, would be my view. Not sure what you think about that, Oliver.
Yeah, completely agree. If you are submitting a claim post or under the new regime, 1st of July onwards, and HMRC don't have any records of any previous claims, they're certainly going to be questioning the validity, I would suggest, that people have been properly placed on furlough, and those types of claims will certainly stand out to HMRC and increase the likelihood of any audit where you're going to have to produce the evidence that of when they were placed on furlough and the confirmation in writing. So I would get the claim in ASAP.
Wendy has asked a question: if they've been put on furlough before and you need to put them back on furlough, does this still need to be done by the 10th of June? Wendy, that's Oliver and I say they don't have to go back on again by the 10th of June. That's our reading of the scheme criteria, but it's the point that I'm saying some commentators are saying they need to be back on furlough by the 10th of June. We don't agree, but of course we are not we are not the HMRC, we are not the Chancellor, and we will only know more next Friday. But we are fairly confident that if they've previously been on the scheme, you don't need to put them back on by the 10th of June.
Further question from John Richmond, just following up on Andy's question about holiday, asking how does that interact with the availability to roll annual leave over for up to 2 years if furloughed, i.e. can a business not allow that rollover and insist annual leave is taken, so not to build up annual leave entitlements for employees? Now, yes, the working time regs were amended by the government to allow up to 4 weeks to be carried over into the next 2 holiday years potentially for the business if they've been adversely affected due to COVID-19. But that is not an absolute right. You as a business can state that you need the employees to be taking their annual leave and not carry over into any subsequent holiday years. So it's your decision as a business to do that and whether you allow that or not.
I think one final question on the chat box, and then we draw that questions to a close. We have someone who is due to go on maternity leave on the 18th of June but are on furlough. Does maternity pay take precedence, or can we keep them on furlough? The answer is that they go on to maternity leave. So you can't have maternity leave and furlough running side by side. If they've already given you notification of that's the date that they are commencing their maternity leave, they move off of furlough and onto maternity leave, which is calculated on their pre-furlough sum of wages at that time. Thanks everyone for your questions. A real wide variety of things there. Hopefully we've been able to help you with those. Oliver, I think you've got another slide to share with the audience, hopefully still at your fingertips that you want to cover.
Yes, let me get that on screen. So we would just like to promote as well a service that we provide to business in terms of ongoing employment and HR advice. It'd be great if we could work with many more of you on that basis, and it's Adapt HR. So this is a bespoke employment and HR advice line that we have many businesses and clients take advantage of, and it's unlimited telephone, email, face-to-face advice now over Teams, Microsoft Teams and Zoom, in return for a fixed annual fee spread over months. So you sign up to a 12-month contract, your costs are fixed no matter the usage, and in return you receive that unlimited advice. Now we'll send out some information on the package following the session as well, together with the slides. And if you'd like further information on that or a quote for that fixed fee, then please contact us and we'll provide that. It really suits businesses because we become an integral part of your business. We get to know you really well, the type of advice that you need, and really provide that commercial, cost-effective legal advice as well. And then Teresa, you're just going to mention the training side.
Yes, just one point about those of you, I'm sure many of you on the call are probably on our advice line Adapt service, and you will know that you've been busy phoning us about the coronavirus job retention scheme, and we've had many queries, and it's all encompassed and incorporated within that package. What we have in relation to training is that we're launching a series of training sessions on key employment law skills for managers. So this is really more focused at the managers about how do they help with managing their staff, and we're going to be launching our 10-part series shortly, which previously we were going to be going round the region and into employers' businesses to do that, but we will obviously be more adaptable in relation to that and be doing them on Zoom and online in relation to that. Thanks everyone for joining us this afternoon. Next date for your diary. So a week on Friday, obviously we've said we're going to have the additional information from the Chancellor. So we will join you again, or we hope you will join us, on the 17th of June at 12:30 p.m. is our next live webinar, when we'll be able to go into the devil in the detail about some of the areas that we have covered today, Oliver and myself. And hopefully we can answer more clearly some of the questions that you have raised with us today. So thanks everyone for joining us. Have a great afternoon, and hopefully see you all again on the 17th of June.